Hi, this is the 3D Printing Lawyer, and today we're diving into a critical yet often misunderstood topic: copyright infringement versus free speech. Whether you're designing, printing, or sharing, it's essential to know the legal and ethical boundaries that govern creative works. Let's kick things off with a common question. Is it copyright infringement to reproduce someone's work verbatim if I don't use their actual 3D object file, but instead create my own? The answer is yes. If the original work is rights protected and you don't have permission from the copyright holder, simply recreating something from scratch doesn't exempt you from copyright law. The law protects the expression of ideas, not just the physical files. Next, what if you copy a rights-protected work but don't do it for profit? Still, yes, that's copyright infringement. The intention behind the act, whether or not you profit, isn't the deciding factor. Copyright law is designed to give creators control over how their work is used, regardless of financial gain. Now, you might wonder, if someone isn't profiting, is there much a rights owner can do? The short answer is yes, there is plenty they can do. Let's break it down. First, you might think you're not profiting, but you're gaining something: the time saved by not creating the work yourself. That saved time has value, and under the law, it's considered damages owed to the rights holder. Additionally, if the rights holder registered their copyright within 3 months of publication, they could claim statutory damages. This means the law automatically assigns damages, ranging from $750 to $150,000, regardless of whether the rights holder can prove actual harm. In some cases, bulk copyright infringement could even be prosecuted under the RICO statute. Yes, sometimes it is RICO. Now let's explore a more specific scenario. Is it copyright infringement to copy a protected Disney work onto a t-shirt before visiting a Disney theme park? Yes, that's still infringement. The fact that you're wearing it for personal use doesn't change the fact that it's unauthorized reproduction of a protected work. And here's a follow-up question. If Disney doesn't pursue a claim against one park attendee, does that mean they won't pursue others? No. Copyright law is different from trademark law in this regard. Failing to enforce copyright in one instance doesn't jeopardize the rights holder's future ability to protect their work. On the flip side, let's talk about trademarks. Is it trademark infringement to put "hot to go" on a t-shirt? Trademark law can get complex. It depends on whether the phrase is registered as a word mark or design mark, and in which category. For example, one company might own the trademark for "hot to go" on t-shirts, while another owns it for underwear. Context matters. Now let's shift gears to free speech. What's worse, ranting or ranting about someone else's rant? Free speech on the internet has broad protections. As long as your speech isn't obscene or inciting someone to react violently, what the law calls fighting words, you're likely within your rights. Talking vaguely about a group of individuals will not be considered fighting words, but targeting a specific person with harmful language might cross the line. But what about using someone else's protected work to make a point? Is that protected free speech? No. Engaging in illegal conduct, like copyright infringement, is not protected by the First Amendment, even if you're making a statement or trying to prove a point. Additionally, in the last few years, states are starting to make doxing someone a criminal behavior. Finally, here's a practical question. How difficult is it to unmask trolls who copy your designs and post them on platforms like MakerWorld? It depends on the platform. Some companies, like YouTube or Discord, are known to resist subpoenas. There isn't an established behavior from MakerWorld yet regarding their users' privacy. However, it's relatively affordable to pursue legal action. For instance, filing a federal DMCA subpoena costs $49. Registering your copyright is $65. Filing a federal lawsuit costs $405, free if you qualify as low income. Serving a defendant in the US is about $75, and international service costs nothing as the defendant's host company foots the bill. Be careful. If someone sends you a cease and desist demand, they're likely at least $500 angry. People who don't have a legal education can offer free legal advice online without consequence, but I'm not so lucky. What I've shared today is opinion and fact, not legal advice for your specific situation. If you're serious about protecting your designs or respecting the work of others, understanding copyright and free speech is critical. Thanks for tuning in. Stay informed and be kind. Until next time, keep creating. Got questions? Drop them in the comments below. Please like and subscribe for more videos on 3D printing.